Okay. Hi everyone. We will get started in just a minute. Um, just waiting for a few more people to jump in. Alrighty. So we will go ahead and get started. My name is Tamerlan Wandler. I am Innovative Benefit Planning's Director of Compliance, and I will be leading today's webinar. So a bit of background on Innovative Benefit Planning. We are a privately owned benefit brokerage firm delivering Fortune 500 solutions to the middle market. So we work within employee benefits, retirement plans, HR consulting, population health management, and we have been around for a little over 35 years. But here's a bit more information of how Innovative works alongside UBA or United Benefit Advisors. So United Benefit Advisors is a organization that has national reach, and Innovative is part of that organization, which gives us the opportunity to work alongside other partner firms around the country. So we are able to stay within our own entity. We are able to stay and work solo, but this does also give us the opportunity to work with other firms on a national level. So with that, I will jump right in. And also, just before we get started, a bit of housekeeping. You are able to ask questions in the chat. So if you do have any questions, you can go ahead and put them in the chat and we will cover that at the end. So we will kick it off with the Consolidated Appropriations Act. So if you've listened to me talk at any other webinar or any of our in-person lunch and learn events, you know that this is something that I bring up often. So just a bit of background on the CAA, or the Consolidated Appropriations Act of 2021. I know at this point, 2021 feels like a lifetime ago, but part of that legislation gave plan sponsors some additional aspects and additional obligations that they need to be aware of, as plan sponsors are ultimately the plan fiduciary. So I'll go over each of these a bit more on the next few slides, but did just want to keep them on your radar right now. So part of those four aspects, or pillars, so to speak, is the broker and consultant compensation disclosure, the gag clause prohibition attestation, RxDC reporting, and the non-quantitative treatment limitation analysis, which is under the Mental Health Parity and Addiction Equity Act. So before jumping into the individual CAA obligations, I think it's important that we note why we continue to bring these things up, why we continue to talk about them, other than the fact that these are obligations that are ongoing that employers need to be aware of. Is one of the big things is the potential for a class action lawsuit or a fiduciary lawsuit. So I've just listed a few of these here. It's a lot of information, so I'm not expecting you to read it, but I will at a high level just note some of these things. The first piece of litigation is against Northwestern University, and this came out June 20th of this year, so a few months ago at this point. And Northwestern is being sued currently by the plaintiffs, who are alleging that Northwestern violated their fiduciary duties by offering a quote unquote imprudent health plan option. And what they're stating, or what the plaintiffs are alleging, is that by failing to select and monitor one of the plan's PPO medical insurance options, and then subsequently failing to disclose the material information to the participants, the plan sponsor violated these duties. So, bit of background here, and I will, keep this at a high level. Northwestern offered 3 health plans. And what the plaintiffs are alleging is that the higher cost health plan, so the gold plan, so to speak, was not providing a better benefit than the lowest cost plan, so the high deductible health plan. This is a novel ERISA claim. They're using the financial dominance test as the basis for the breach. It remains to be seen what's going to happen. As of a few days ago, there was a motion to dismiss filed by Northwestern. We'll see what ultimately ends up happening with that. However, it is something interesting to think about because as you'll see with the other litigation, this claim is going directly against the health plan versus the prescription drug plan. So as we start to think about plan sponsors, their obligations, and towards the end of the presentation, I'll walk through a few things that plan sponsors can start to think about from a fiduciary perspective. But as you're reviewing your plans as a fiduciary, you're trying to think about the best approach for your participants. And maybe that is offering more than one health plan to give your participants options. So if this claim were to go through, it kind of raises this question of how are plan sponsors supposed to provide their participants with the options by providing different options. How are they supposed to provide them with multiple costs, all of these other items, but still avoid potentially being subject to a lawsuit? The next item here is the Johnson & Johnson lawsuit. So this came out in 2024. However, we still include it because especially recently, there was a motion to dismiss that was approved. This motion to dismiss was on a second amended complaint, so this case was dismissed previously. It was also dismissed without prejudice, which means that the plaintiffs could bring it again if they determine that they do have standing to bring the case, or they could appeal it. But basically, the court was saying that the claim was too speculative, that the allegedly excessive fees the plan paid to its PBM had any effect at all on the plaintiff's contribution rates and out-of-pocket costs. So as I mentioned a few minutes ago, these next few cases are related to the prescription drug plan. So the plaintiffs were alleging that they paid more for their prescription drug plan than they really should have, therefore saying that J&J was receiving an additional benefit and not acting in the best interest of the plan participants. What's interesting about this case, and I'll note that on the last item here, is that similar reasoning or similar standing arguments were utilized for that last case. However, that last case was eventually determined in favor of the plaintiff. So it's interesting to see that the court in this case determined basically the opposite. So we'll see what ends up happening here. And then the next one here is against Wells Fargo. Similar situation. The plaintiffs were saying that there was mismanagement of the employees' drug benefits, and that case was also dismissed without prejudice on standing grounds. Again, we will see what ultimately ends up happening with these cases. If the plaintiffs decide that the case is worth pursuing again, they may refile. And then finally, this last item here is against the Blue Cross Blue Shield of Michigan. So as I mentioned, this one did ultimately be decided in favor of the plaintiffs. And the reasoning was the defending carrier acted as a fiduciary for the plan governed by ERISA and therefore violated its fiduciary duty by overpaying providers for services rendered. So, just something to keep in mind. And why we mention this, as always, is that you as the plan sponsor, you are ultimately the plan fiduciary. So you want to be reviewing your plans and making sure that the way that your plan is running is ultimately in the best interest of your plan participants. So with that, I will move into actual CAA obligations and why we're talking about this. So the first item here is the broker and consultant compensation disclosure. So this was initially required or effective December 27, 2021. So like I said, this is all part of the CAA 2021, but it is an ongoing requirement. And this requirement is very similar to what we saw on the retirement side that has been in effect for years. And basically what this says is that brokers and consultants who will who will receive in excess of $1,000 for a contract or an arrangement for services are obligated to provide plan sponsors with a compensation disclosure that outlines their direct and indirect compensation. And despite the fact that this is a broker and consultant obligation, as the plan sponsor, you have the obligation to review these disclosures for reasonableness. When you're looking at it, does it make sense based on the services that you're providing? It doesn't make sense based on your understanding of the way the plan is being run, the way the plan is set up, that the fees outlined are in line with those things. The next item here is the gag clause prohibition compliance attestation. So it's a bit of a mouthful. And what this is that it says that employer-sponsored group health plans are prohibited from having contracts with their providers, third-party administrators, their carriers, their PBMs that contain gag clauses. And a gag clause is just a legalese way of saying that there is a provision within the contract that allows the party to withhold certain data from the other party. One of the big focuses with these obligations under CAA is transparency. Recognizing that there is this lack of transparency in healthcare costs continue to rise. This is one of the ways that the government is attempting to address that issue. So what this requirement is that by December 31st, every year, plan sponsors or health plans or the TPA or the PBM are required to upload a gag clause prohibition compliance attestation to the CMS website. In some cases, the plan sponsor may be able to rely on their carriers to upload this attestation. Typically, we see on the fully insured side that the carriers are handling this, as the fully insured carriers have greater fiduciary obligations than the carriers on the self-insured side. However, there are instances in which the self-insured carriers are uploading this. So one of the things that Innovative does is we reach out to the carriers, confirm how they are addressing these things, receive any kind of compliance notice that they may have, stating specifically that they have removed these gag clauses. And then from there, we inform the client that whether or not they would need to upload the gag clause themselves. We do also, in some instances, offer to assist clients with that upload. But I will say it's relatively straightforward, but it is due by December 31st. So within 2-ish weeks, so it is definitely coming up. The next item here, I know, again, a lot of words. I'm not going to spend that much time here because I have talked about this in the past, but did just want to mention specifically the first item here is this downstream agreement. So we received additional FAQs from the departments, and what they said is that the contracts between the plans, carrier, TPA, PBM, and a third party that they may work with to administer the plan's network, if those agreements contain a gag clause, by extension, the employer's agreement with the TPA carrier, etc., contains a gag clause. So this is interesting because in many instances, the plan sponsor has no insight into whether or not these downstream agreements exist, what the language is. So in light of that, the departments released additional clarification in which they state that a plan who is unable to verify whether the agreement actually contains the gag clause, or if they receive the agreement and they note a gag clause, they are able to, within the attestation, include additional information. And in that additional information, they can simply state, it's our understanding that there are gag clauses within this agreement. And the departments will see that as a good faith attempt to comply. Whether folks are going to do this, whether the carriers are going to do this, I think it remains to be seen, but it is interesting because I think the government is noticing or recognizing that it may be hard for plan sponsors to actually confirm these things. And in doing that, they're trying to provide a bit of relief in light of this additional clarification. This next item here is the RxDC reporting. This is due June 1st of every year. So the next one is June 1st, 2026. So you do have some time. And what this is plan sponsors and TPAs carriers need to upload on an annual basis a number of data files that outline the 50 most costly drugs, the 50 most dispensed drugs, and the 50 drugs with the greatest increase in planned expenditures. It also needs to outline different demographic information related to the plan. For the most part, again, fully insured plans are largely able to rely on their carriers. Self-insured plans, at least from our experience from the past few uploads, is that self-funded plans are able to rely on their carriers as well. However, most of the time, the carrier will request some additional information. This is another instance in which, to assist our clients, we reach out to the carriers, confirm how they're going to approach it, and then discuss with the clients their preferred approach with this, whether it's they allow the carrier to upload or they want to take it upon themselves to upload. This is a heavier lift than the gag clause attestation, but ultimately, in some instances, plan sponsors review with their fiduciary committee and decide that they feel better to upload their own file, and they go that route. The next item here is the non-quantitative treatment limitation analysis. So at a high level, the NQTL analysis is part of the Mental Health Parity and Addiction Equity Act. And this analysis has been in place for years. However, it really wasn't until the CAA that folks really needed to start focusing on this. So while this obligation existed, there wasn't really mechanisms for review, or at least the reviews that were happening from the DOL weren't as robust or consistent. So what this says is that if your plan offers mental health and substance use disorder benefits, those benefits need to be in parity with your medical surgical benefits. So basically an NQTL is a plan limitation that, say, for example, you have a prior authorization on an inpatient service on the mental health side, but a comparable service on the medical surgical side, there is no inpatient prior authorization requirement. Now, that's something that may raise a red flag from a parity perspective. So what this says is that these analyses need to be completed. Again, fully insured plan sponsors are largely able to rely on their carrier to handle this. On the self-funded side, this obligation does fall ultimately on the self-funded plan in order to conduct this analysis. This analysis is relatively complex. And in the event that there is a determination that there is non-compliance, say, for example, the DOL audits, or a disgruntled plan participant makes a complaint with the DOL and then the DOL steps in, the plan sponsor will need to notify their plan participants and beneficiaries of the determination. They need to remove all NQTLs for mental health and substance use disorder benefits, and then there is this potential for a civil monetary penalty. So the implications are pretty steep if there was some kind of failure. So there are two options for evaluation. The DOL has prepared a self-compliance tool. What I will say with this is that it isn't the right fit for every plan sponsor. And I think that for a majority of plan sponsors, it most likely is not the end all be all from an analysis perspective. If you do have somebody within your office that is very well versed in the plan, maybe they have, excuse me, conducted similar analysis in the past. Maybe this is something that you can use. At minimum, it's something that you could potentially use to do some kind of over the shoulder review just to kind of see where you're at. The second obligation or the second option is engaging with a third party vendor. This is largely what we see plan sponsors leaning towards. With that said, the pricing ranges depending on how many plans you have, how big your company is, various items can potentially increase the cost. However, at least from what we're seeing, is that a number of plan sponsors are not doing this analysis. And it has been a common approach to be reactionary versus proactive. So in the event of the audit, that's usually when the plan sponsor is opting to complete the analysis. I wouldn't be the compliance person if I didn't state I don't suggest that approach. I think it's always better to be proactive, especially if you do ultimately have some kind of NQTL in place. It's much easier to fix that prior to getting the audit. Because as you notice on the previous slide, the time frame in which you need to respond is very short. So say, for example, you engage with a vendor who currently has a backlog. Just because you have a DOL audit doesn't mean that they're going to be able to put you ahead and complete that analysis within a very short amount of time. So just something to think about. One other thing I wanted to note here is the final regulations. So these final regulations were released in 2024. However, they have been paused. The reason that this is important to note is that one of the items within the final regulations was that plan sponsors or plan fiduciaries were required to certify that they engage in a prudent process to select a qualified service provider to conduct the analysis. So this is another reason why, typically we suggest engaging with a third party versus just relying solely on the self-compliance tool. However, with that said, again, these final regulations are paused. That does not pause the obligation to conduct the analysis, but it does pause the additional obligations that came out of the final rule. One of the things that we've been doing is we reach out to the carriers, see how they're complying, confirm. Most carriers state that they are in compliance. In some instances, they will provide additional documentation outlining these things. In other instances, they state, we'll give you the information if you're audited. But for the most part, in our experience, the carriers are saying that they're in compliance. The next item here quickly is just some high-level items that came out of the most recent spending bill, specifically the HSA expansion. This was effective January 1st, 2025, so it was retroactive to the beginning of the year. And what this says is that the HSA expansion for telehealth is permanently expanded. So I'm sure you remember during COVID, there were a number of regulations that came out that said that you could have on your plan telehealth covered at zero cost share prior to the individual reaching their high deductible health plan deductible without disqualifying the plan and without preventing the individual from being able to contribute to the HSA. That flexibility is now made permanent. The second item here, and this is effective for 2026, is plan sponsors are able to increase their contribution amount through the dependent care FSAs up to $7,500. So this is the first time since the start of dependent care FSAs that the contribution amount was increased from $5,000, with the exception of during COVID, in which it was briefly increased to $10,000. So this may be welcome for plan sponsors, may not necessarily be welcome for may be welcome for plan participants, may not be welcome for plan sponsors, or sometimes it is welcome for plan sponsors if their plan participants are not necessarily utilizing the plan. The reason I say that it might not be welcome for plan sponsors is because if you were to increase your limit, there is a risk of failing your non-discrimination testing under IRC Section 129, which is relevant to your dependent care FSA. With that said, non-discrimination testing, you don't know if you fail until you test. In the event that you do fail, you are able to make those corrections. We typically suggest testing mid-year, just so that if you do need to implement corrections, you have a decent amount of time to do those things prior to the end of the year. The corrections are typically relatively straightforward, but just something to think about if you are considering making this adjustment. There may be non-discrimination testing implications. With that, we'll move into the Affordable Care Act. So the first item here is the just high-level minimum essential coverage. So just as a reminder, employers with 50 or more full-time or full-time equivalent employees must offer minimum essential coverage to 95% of your full-time employees. In the event that that is not the case, you may be subject to an A penalty or the hammer penalty, which applies to all employees within the employer, and that has increased to a little over $3,300 per full-time employee, so pretty steep. The next item here is related to the B penalty. So what this states is that employers need to offer affordable coverage, and meaning that the contribution per single coverage does not exceed for 2026 9.96% of the employee's household income. So this is an increase from 2025, and employers are required to offer minimum value coverage, which means that an employer's plan provides minimum value if it covers at least 60% of the total allowed cost benefit. So as I mentioned, this is where the B penalty may come in, and the B penalty is applicable only to the employees who go to the marketplace to receive a subsidy. However, for 2026, that penalty did increase to a little over $5,000 per full-time employee who receives a subsidy. So can potentially be pretty steep depending on the number of employees. So here we have a timeline of the reporting. So for 2026, if you are filing by paper or to the IRS, that due date is March 2nd, 2026. The due date to distribute the documents or the forms to your employees is also March 2nd. And then the deadline to distribute the forms directly to the IRS if you're filing electronically is March 31st. There are penalties for late or incorrect filings. It's $340 for forms that have issues that are furnished to employees, $340 for forms that are issued to the IRS. In some instances, the IRS will reduce these penalties if they are corrected. And then do just want to note that employers filing 10 or more forms in the aggregate must file electronically. So typically we see that this is applicable across the board, but did just want to note that as well. And then also wanted to include some state-specific reporting deadlines. So New Jersey, Washington, D.C., and Rhode Island have additional obligations. So to the employee, you have to provide the forms by March 2nd. And then you also have to provide those forms to the state specifically by March 31st. California also has similar obligations. However, their employee deadline is the end of January, so much sooner than the other state. And then finally, Massachusetts to the employee also by the end of January. And then the Massachusetts HC 1099 needs to be provided to Massachusetts by the end of January as well. So Massachusetts is definitely one of the ones to keep in mind since it is much sooner than the others. So another item here to think about is the Employer Reporting Improvement Act. So this came out towards the end of last year. And what this did was it codified employers' flexibility to utilize the employees, the spouses, the dependents' names and date of birth in lieu of a TIN or social security number on forms 1095B and C. And if you've ever had to file these forms and you receive some kind of TIN error from the IRS, you know that it can be difficult to collect these confirmations, especially when it's an employee's dependents. In some instances, the dependent doesn't have a TIN, or you receive the confirmation and the employee gets back to you and says, nope, that's correct. However, you're still consistently receiving these errors. So what this regulation said is that this flexibility is permanent and it is codified. Previously, the flexibility existed. However, there were multiple steps that the employer had to go through by trying to confirm with the employee. This streamlines this approach a bit more. It also allows employers to electronically distribute these forms, the 1095B and C, to covered individuals versus having to physically give them the forms or mail them. And then additionally, it extended the response period for proposed assessments from 30 days to 90 days, which is it's a big deal. If you have ever received what's known as a 226J penalty letter from the IRS, you know that if you are going to appeal that, and those would be where you would see the A penalty and the B penalty that I mentioned, there's a lot of information that may need to go into that appeal. So having the additional 60 days is a big deal for employers. They're able to collect those materials if they want to appeal, get all their ducks in a row, and provide it back to the IRS to hopefully be successful in an appeal of the penalties. It also provided a 6-year statute of limitations for the IRS to collect penalties. Previously, there was no statute of limitations. So if you've ever gotten the penalty letter, you'll see that even though we're in 2025, you may receive a penalty letter for 2022 or 2021. Obviously, I recognize that that is less than 6 years, but it's several years ago. So do you have all that documentation? Are you able to contact the employees if you need to verify anything? So it's a lot to collect, as I mentioned on the other bullet. That's why the 90 days is important. This next item is the Paperwork Burden Reduction Act. So this was also rolled out at the same time as the Employer Act that I just talked about. And again, it does also codify similar things. So it codifies the ability for plan sponsors to be able to utilize electronic methods to distribute the 1095s. But it also states that plan sponsors are no longer required to automatically distribute these documents unless the employee specifically requests. So previously, this existed for smaller plan sponsors for 1095Bs. So this has now rolled out to the 1095Cs. And if you've ever had to deal with this, you know how burdensome it can be to make sure these documents get sent. So this is stating that you no longer need to do that. It does not remove the requirements under state specific. So if you live in California, New Jersey, those obligations still exist. But on a federal level, you no longer need to distribute them to satisfy the federal requirements. With that said, if you want to take this approach, you need to provide your employees with clear, conspicuous, and accessible notice that outlines their ability to request a copy of the form. So what that means is you can't just decide that you're not going to distribute it and not tell anybody. You do need to make sure that your employees are aware. So maybe it is that you post it on your intranet site that all employees have access to, or you send out a company-wide email, or you put it in a notice packet. You want to make sure that your employees are well aware of this. And then the final item here is that if an employee makes a request, you must provide that form by the later of January 1st of the year following the form's reporting year, or 30 days after receiving the request. So you do have some time to provide that form. However, the obligation to provide it is still there. You don't want to not have it ready to go if the employee requests it. There may be concerns around penalties in the event that you cannot provide this and the employee lodges a complaint or the IRS gets involved. So definitely want to make sure that you still have these documents ready to go, especially since you have to file them with the IRS anyway. But still, this is very welcome for so many plan sponsors, as this obligation can be very burdensome. And then the next item here is related to some penalty litigation that was determined recently. And what happened, just at a high level, is a company received a penalty letter in 2021 for health insurance that they were not offering in 2019. So again, this is where that 6-year statute of limitation kind of comes in, because it was 2021 when they received the letter. 2019 was what the penalty was for. But the penalty was relatively steep. It's over $200,000. And that's because it was that A penalty. And despite the fact that the employer paid the penalty, they did include a note that stated that they were paying under protest. And then when the IRS did not respond, they filed a refund claim and a lawsuit. So ultimately, this made its way all the way through the courts, and the court agreed with their argument and ordered them to refund the penalty. Specifically, they stated that the IRS has not been delegated the responsibility to issue these penalties and to certify these penalties by HHS. So under the ACA, it's HHS's responsibility to make these determinations of penalties, of reasons to issue the penalties, and then provide notice to the employer, provide them the ability to appeal. And the ACA never delegated that responsibility to the IRS. So if you have ever received a penalty letter, you know that it is coming from the IRS. So this is interesting. What this means going forward remains to be seen. It's entirely possible that other employers are going to take the same approach, and then we will see maybe an overhaul of this process, an overhaul of the 226J letter penalties. With that said, this does not have any direct impact on employers outside of this litigation as of yet, but it is still something to think about. You know, I'm not saying that you should forego any other responsibilities related to the ACA. I'm not saying that if you get a penalty letter, you should ignore it because of this litigation, but it is just something I wanted to mention. And then finally, the last item here in this section is something that is, I think, top of mind. And that is the ACA enhanced subsidies. So what these are, and I think that this is something that has caused a bit of confusion, is that the enhanced subsidies were part of the American Rescue Plan Act and then extended by the Inflation Reduction Act. And what they did was it temporarily expanded the eligibility for reduced health insurance to Americans whose income exceeded 400% of the federal poverty level. In some instances, folks were receiving or were able to receive coverage at $0. So it did impact people in a major way. These enhanced subsidies were always set to expire at the end of the year. And there was this push to extend them. There was back and forth during the government shutdown. Right now, it remains to be seen what's going to happen with this. So as of yesterday, it didn't seem like there was going to be a vote at all. However, it seems like maybe that is not the case, and there are some other senators or House people who have decided that they still want to have a vote, so they might try to force the vote. But either way, it remains to be seen what's going to happen. Ultimately, this needs to happen before the end of the year, which is very soon. So we're getting into some of the other holidays that are celebrated, so Christmas time and New Year's. So how many Congress people will be in office? Unsure. So it remains to be seen what's going to happen. But one of the things that I think causes a bit of confusion is related to these subsidies in general. So these are only enhanced versions of the subsidies that were already in place as part of the ACA originally. So what would happen is that if these ultimately are not extended, those original subsidies will be put back in place. It will revert back to those things. What this will likely cause is an increase to health insurance premiums for all of these folks who were previously able to qualify for these enhanced subsidies. In some instances, there are folks that were qualifying for the last few years that will no longer be able to qualify at all based on their income. It is anticipated that these premiums are going to hike. So it will be interesting to see ultimately what happens. But why we included this here is there are some things to think about as an employer. So it's anticipated that employers may see an increase in plan participation. Folks who were able to receive coverage through the marketplace at zero cost share or a exponentially reduced cost share are no longer, may not be able to receive that at all. So then in order to have coverage, they may be coming onto the employer plan. Something else to think about is that folks who were previously covered, maybe they can't afford their employer's plan and they also can't afford the marketplace coverage, may opt to forgo health insurance entirely. And therefore, when they need coverage, may ultimately end up seeking the coverage through emergency resources because they're unable to pay. And under EMTALA, the emergency rooms are still required to cover these folks. They won't get paid. Eventually, those things may trickle down to the employer and their premium coverages. So also something to, to think about. And one other thing I wanted to add here is that we're getting towards 1/1. So if the enhanced subsidies are not determined by the end of the month, but then maybe in February there's a vote, or even if there's a vote in January 5th that decides to extend these subsidies, employees who have enrolled in the plans in the employer's health plan may not have a special enrollment period that would allow them to drop that employer's coverage to then enroll in the marketplace coverage where they are now eligible for a subsidy again. So it will be, again, interesting to see what happens. Now, if they were enrolled in other marketplace coverage and they received the subsidy, they may be able to, at that point, enroll in a different marketplace plan that might be cheaper. But in the case if they're enrolled in the employer's plan, they may not necessarily be eligible for any kind of special enrollment period to allow them to disenroll from the employer's plan. It is possible for the employer to add this type of special enrollment period to their plan. With that said, that might not be feasible for all employers. There may be issues from a carrier perspective. So again, we're kind of in this wait and see period right now with this. Now I have a few legislative updates. So the first one here is related to the Delaware pay transparency law. In the interest of time, I won't go through too much of this, but just at a high level, Delaware has joined a growing number of states who are implementing pay transparency laws. And what this says is that employers in Delaware are required to include wage and salary ranges and information on benefits offered in job postings starting in 2027. So there is some time to comply, but did just want to mention, just so if you are in Delaware or you have locations in Delaware, just something to think about. So specifically, hourly and salary compensation ranges must include your minimum to maximum pay range for the position that is quote unquote set in good faith, the actual range of others currently holding the equivalent positions, or the budgeted amount for the position. Employers are also required to provide pay and benefit information to the applicant prior to any discussion of compensation. And the law specifically is applicable to Delaware employers with more than 25 employees posting jobs located in Delaware and non-international remote positions, and does not impact interim or temporary jobs. And with that said, there is, as with so many pieces of legislation, there are potential violations if the employer is not complying, which range from $500 to $10,000. And that's dependent on the level of non-compliance. If it's a mistake or if you were not warned yet, maybe it'll be only around $500. If it is a recurring issue and you have been notified multiple times, that's where you start to get creep closer to that $10,000 range. The next item here is the California Pay Transparency Law. So this pay transparency law was already in existence, and it required employers with 15 or more employees to include pay scale for the position in any job posting. The law has been modified to include the definition of pay scale to mean a good faith estimate of the wage range the employer reasonably expects to pay for the position upon hire. Additionally, the Equal Pay Law was also amended to add a definition of wages and wage rates broadly to include a number of things. So all forms of pay, including but not limited to salary, overtime, bonuses, stock, profit sharing, bonus plans, as well as other benefits like life insurance. So this expanded pretty significantly. Now, like I said, this has already been in effect. So California employers are aware of this. They have been complying, but I think it is just important to note that there are some clarifications. As with any piece of legislation, you always want to be mindful of the potential for changes. This next item here is related to the HIPAA notice of privacy practices. So an updated notice is required for covered entities by February 16, 2026. So within around 2 months from now. And what this is this new notice needs to align with additional privacy regulations that are related to substance use disorder patient records. So the updated notice must address the use and disclosure of substance use disorder treatment records that covered entities may receive from a treatment program, also known as a Part 2 program. And the notice should address how the covered entity may use the treatment records. If there are any kind of fundraising communications, the individual must have the right to elect not to receive any of these communications. And then also a prohibition on use or disclosure describing the information in any civil, criminal, administrative, or legislative proceeding. So we're anticipating that HHS and CMS may release a revised model notice. I have not seen the notice yet, but either way, if you are considered a covered entity, it is important that you make sure that your notices are updated. This is something that Innovative is assisting with. We're monitoring the model notice to see if we can locate any model notices. But again, this is required by February 16th. The next item here, just at a high level, is related to state laws regulating PBMs. I won't spend too much time here, just in the interest of time, but did just want to note that we are seeing states that are passing laws regulating PBMs, and they're mainly focusing on PBMs who also are in ownership of pharmacies, trying to focus on mail order pharmacies, mandatory pharmacy reimbursements. So remains to be seen what's going to happen. If you remember a few months ago, Arkansas signed a PBM law that was relatively strict. There was some litigation related to it to try to overturn this legislation because it did very negatively impact CVS, where CVS was removing all of their pharmacies from within Arkansas. So that could be a huge issue for individuals who only have access to a CVS. So remains to be seen what's going to happen. But I think it is interesting that we are seeing this because it really does highlight that states are recognizing, again, thinking about the CAA, transparency, they're recognizing the high costs of prescription drugs and are attempting to come up with ways to address those issues. With that, I will touch on a few things under the Secure Act. So just quickly at a high level, Secure 2.0 is related to retirement plans, specifically 401k, 403b plans, and it is the Part 2 version of the Secure Act 1.0. And these regulations were released because the federal government recognized that we are in a retirement crisis where folks are unable to save up enough for retirement. Maybe they're working beyond normal retirement age, and because they do not have the funds necessary in order to be able to retire. So one of the obligations here is effective 1/1/2026, and it states that individuals meeting the salary threshold of $150,000 who are eligible for catch-up contributions will be required to make those contributions on an after-tax basis. So it is removing the ability for some folks to contribute on a pre-tax basis to the 401k or their 403b. So they are required to convert those additional contributions to Roth catch-up contributions. This requirement was initially effective a few years ago. However, recognizing the administrative burden that it would put on plan sponsors, it was delayed until 1/1/26. So some employer considerations here. So for wage calculation purposes, wages can be aggregated or not aggregated across employers in the same control group. However, if you are going to take this approach, you want to make sure that your plan documents are amended to reflect the choice. If the participant is subject to the Roth catch-up requirement and is making pre-tax deferrals, plan sponsor can elect to have any catch-up contributions as Roth, which is known as the deemed approach. However, the participant must have a timely opportunity to choose something other than the deemed election. So if you are taking this approach, want to be mindful of this notification requirement, of this timely opportunity requirement, because especially since we are getting closer to the effective date of this obligation. And the deemed approach would allow the plan sponsor to use two correction methods when the catch-up contributions are mistakenly made on a pre-tax basis. So you have the W-2 method, which is available only when the W-2 has not been filed yet, or the plan Roth rollover method, which would come up if the W-2 has already been filed. Some additional considerations. So you want to determine what tasks will be performed by you as the plan sponsor, by your record keeper, or other service providers when implementing the mandate. As always, want to make sure that you are documenting everything. Any approach that you take, and this is the same case with any changes that you're making to your health plan as well, I want to make sure that you're documenting these things. In the next few slides after this section, I will talk about some of those obligations from a fiduciary perspective, but it's always important to have the document in place for any mandatory changes or even any changes that are elective. I want to make sure that your plan documents are updated. So just thinking about some questions. Who will identify the employee subject to the mandate each year? Is it going to be you as the plan sponsor, your record keeper? Who's going to identify the first payroll period when the mandate applies? And then how is this going to be communicated? And then if elections are made by participants, how will this be communicated so the change is made in payroll? Again, how are we communicating to the employees? How are we communicating it to your record keeper, to whomever is in charge of your plan document who may need to make those updates? Make sure that you're documenting these things. Make sure that you are giving yourself enough time to make those changes. As you saw in the previous slide, there are corrective actions that can be taken, but you don't want to end up in that position if you can avoid it. Innovative is able to assist with these things. We do have, as I mentioned way in the beginning of the presentation, we have a retirement arm that is more than happy to assist. They're currently working with our current clients, going through this process and outlining these obligations and talking them through with our clients. And with that, with the last few minutes that we have, just going to quickly go through some roadmap to compliance here. So I talked a lot about being a plan fiduciary, your obligations, your CAA obligations, your obligations on retirement side, on the Secure Act, as well as just being mindful of some of these pieces of legislation that are coming out and you as the employer may be subject to. So something that we discuss with our clients, we offer to walk them through a fiduciary process and do kind of a fiduciary assessment is with this slide. So we always suggest you want to, establish the fiduciary charter. One of the first things we talk about is establishing a fiduciary committee. Typically on the retirement side, you likely already have something like this, but not many employers have this on the health and welfare side, just because health and welfare plans typically follow slowly behind retirement plans when it comes to pieces of legislation and obligations. So first thing, want to make sure that you have some kind of fiduciary committee in place. You want to have a charter in place where you're delegating different obligations to the folks on the committee. Once those things are in place, you're analyzing your agreement. So you're looking at your agreement between your broker and your consultants. You're looking at your agreement between your carriers and your providers. Do these agreements make sense? Do they contain the gag clauses? Are the fees outlined in line with our understanding? And then you want to execute those things. If there's something that you see within those documents that maybe doesn't make sense, or you're noticing that, okay, our expenditures on these things are increased when, how can we prevent that? How can we lower those costs? So once you have the documentation in place, you're able to make those changes. So like I said, you want to define these things. You adopt the fiduciary committee. Maybe you get fiduciary insurance to make sure that if there is an issue, you have some kind of coverage. You can mitigate a bit of a risk. And then, assess that risk and analyze your data. So you look at these documents and where are we at? Okay, we have very high costs on these drugs. Is there a potential to lower those costs? Is there a different program that we can put in place that may help us with lowering those costs? Analyze that data, review your plan documents, and make sure that your plan is running in accordance with those plan documents. Are you making decisions for the plan that is not in line with the plan document and how it's drafted? Are you making sure that your plan documents are being updated regularly to ensure that any changes that were made are part of the documents, are incorporated? And then, of course, you want to execute and measure. So you made the changes, you developed a strategy, you need to actually put it in place. And then after that, monitor it. You're measuring the success. Was the approach that we took the best for the organization? Was it the best for the plan participants? Do we need to make adjustments? Make sure that you're documenting all of these things and you're discussing them internally with your fiduciary committee. This is just a sample of the due diligence checklist that we put together, and just to assist our clients with their obligations. This is something that you can take back to your fiduciary committee and just outlines where you maybe made some changes to your plan, maybe you opted not to make a plan, and the reasons behind it. Because even though we're seeing these fiduciary class actions, that doesn't mean that you need to make every single change that you evaluate. If there is a change that you want to put in place, or there's a change that may be a huge impact to your plan participants, as the plan sponsor, as the fiduciary, maybe it is not in the best interest for your plan participants to make that change. So again, document that. And then here on the last slide is just some upcoming events that we have. This is the last event in 2025. And then we are kicking it off shortly into 2026 with February 5th. We have our mental health first aid training. And then April 8th is our first quarterly compliance webinar of the new year. So with that, I will conclude the webinar. I don't see, checking to see if we have any questions anything in the chat? I don't see anything. So give you guys another couple seconds if you do have anything. No? Okay, great. I know that was a lot of information. I went through a lot of things. I usually say that the fourth quarter is relatively slow. In this case, maybe it wasn't. So if you do end up having any questions after the presentation, feel free to reach out. You can reach out to your account team. If you are already an Innovative client, you can also reach out directly to me. I'm happy to help with any questions you may have. And then with that, I will end the event. Thank you so much for joining. We will send the information around for any of the continuing education credits. Happy New Year and happy holidays.